Hello, everyone. Thank you for joining us today and welcome to our webinar. My name is Carly Thorpe and I'm joined today by my colleagues Sam Parkinson, Seamus Cram, Amelia Speshko and Andrew Dixon. We are all part of the construction and engineering team here at Walker Morris, and we are going to talk to you today about some tricky topics in adjudication. Now, before we get into that, just a little bit of housekeeping. To get the best from this webinar, I recommend that in the top right, you click on layout and switch it to grid view. And that you also select automatically hide names when not speaking. Bit of technical stuff for you there. If you have any questions throughout this webinar, please do drop them into the Q&A and we will try and answer them as we go along. This session is being recorded, so a recording will be available in due course. And as we go through today, we will mention quite a few cases. Now, after the session, we'll email to each of you a handout, which will list each case and have a link to the judgment. So you don't have to worry about scribbling down the cases as we go along. You can just relax and listen. Now, we wanted to focus on these 4 tricky topics of fraud, natural justice, smash and grab adjudications, and insolvency, because these are the topics that we've seen come up time and time again in front of the courts. We're constantly advising clients on these issues, and we've seen different adjudicators take slightly different approaches to similar situations. So they feel like these are real topics where you have to be careful during adjudication. So without further ado, let's start with our first topic, which is fraud. So, Seamus, what are the general principles regarding fraud in adjudication, please?
Carly, so the general position regarding fraud is that fraud can be raised as a defence within either the adjudication itself or in subsequent enforcement proceedings in order to try and resist the enforcement of the adjudicated decision. The general approach of the courts is not to enforce adjudication decisions, where to do so would actually be to perpetrate a fraud. However, it's clear that a party that's relying upon alleged fraud must raise those allegations as soon as it possibly can and within the original adjudication proceedings, if at all possible. As you might imagine, establishing fraud practically is always going to be a matter of getting the factual evidence in place, and this will inevitably be quite a case-specific exercise. The courts have also indicated that clear and unambiguous evidence of a fraud is going to be required in order to persuade the courts not to enforce an adjudicated decision.
Great, thank you. One of the arguments that we've seen raised a lot with regards to fraud is where you've got a situation where a particular invoice or an application for payment appears to have been overstated, so that one party might be claiming more than they're actually entitled to. Now, does that amount to fraud, Seamus?
In general, no. And the key case to think about here is called SG South Limited and King's Head Cirencester. That's a 2009 case in which it was found that payment invoices which contained allegedly overstated or doubly claimed items in an interim or final account don't automatically meet the threshold for fraud. In this particular case, the judge said, quote, "Builders often put in final accounts which exceed by a substantial amount what the employer and his consultants think is realistic," end quote.
Yeah, I mean, to a lot of people, that might seem a bit unfair that a party can ask for money that they know that they're not entitled to, and that's not enough to be a fraud. Did the judge explain why they reached that conclusion?
Yeah, so the judge went on to comment as follows. Fraud is a very serious charge to make in civil proceedings of any sort, and this applies equally, if not more so, in adjudication enforcement proceedings, when it'd be very easy to bandy about fraud allegations to seek to avoid enforcement, end quote. So I suppose what the court's saying there is that there is a very high evidential bar in order to establish fraud, and the courts are trying to dissuade parties from simply thrown in for a fraud allegation in order to seek to avoid enforcement of an adjudicated decision.
So what advice can we give to a party who's faced with that scenario where the other party's overclaiming?
Yeah, I think the best practical advice is to ensure that either a payment notice or a pay less notice is served in time. where there's a substantial dispute regarding the valuation of a payment application. This is usually the best way to challenge an interim or a final payment application rather than seeking to rely on fraud arguments later on.
Okay, good advice. I mean, so the clear message that we've seen from the courts seems to be that fraud is a really difficult argument to establish. Can you give an example, please, of an argument that's failed?
Yeah, so the case of BM Services and Grey Line is an interesting one. It's a 2018 case which Walker Morris acted in. I think you acted in personally,
I
Carly.
did, yes.
So I suppose in this particular case, the key allegation really related to whether documents prepared as part of the process of valuing the works had been prepared genuinely and honestly. The party resisting enforcement of the adjudicator's decision argued the court shouldn't enforce the adjudicator's decision because of the alleged fraud.
Right, and why wasn't that argument accepted?
Well, the court found that the adjudicator had actually considered the issue of the alleged fraud and reached a decision. There was also insufficient evidence in the court's view in order to make out the fraud. The court also commented that when assessing an allegation of fraud, an adjudicator doesn't necessarily need to refer to every single aspect of evidence put in front of him or her. They have a degree of latitude in reaching a binding decision.
Right, and I remember that the timing was important in this case as to when the fraud allegation had been raised. Could you just explain that, please?
Yeah, absolutely. So the general position is that fraud won't usually succeed as a defence in enforcement proceedings where the allegation of fraud could have been raised during the adjudication itself. So the courts won't be too stringent, as I said, in requiring adjudicators to assess all the evidence relating to the alleged fraud, so long as they're deemed to have done a reasonable job in weighing up and reaching a decision on that issue.
Okay, great. What other examples do we have of where fraud allegations have failed, please?
Well, there's a 2010 case called Spey Mills and Baskind, which is getting a little bit older now, but still relevant and quite interesting. This case actually went all the way to the Court of Appeal, who eventually enforced the original adjudicator's decision, which I suppose shows how finely balanced facts were in this particular case.
So, I mean, what was the allegation of fraud in that case then?
Yeah, so the adjudication really turned on the question of whether withholding notices had been served in relation to 4 interim payment applications. The party that was defending the adjudication, Mr. Baskind, alleged that the other party's employees had broken into his premises and actually stolen hard copies of the withholding notices, which he said amounted to fraudulent activity.
Right. Well, that all sounds very dramatic. Why wasn't that considered enough to be fraud then?
Well, the court confirmed that, as I said, in general, while fraud or dishonesty defences can be raised as enforcement, these really do have to be supported by, quote, clear and unambiguous evidence, end quote, and that the allegations have to be made within the adjudication proceedings wherever possible. In this particular case, the adjudicator had actually considered and dealt with the alleged fraud, which prompted the court to enforce the adjudicator's decision.
Right. So that's a good example then of where the adjudicator actually considered the allegation of fraud during the adjudication, and the court took the view that they were going to uphold the adjudicator's decision and wouldn't accept that same argument during the enforcement proceedings. So I think that demonstrates like the general approach of the courts, that the adjudicator's decision should be enforced and that they won't get into the substantive decision made by the adjudicator. Just going back to this inflated or exaggerated invoice and payment application point, that's something that we've seen a lot in practice. So I think it's worth talking about that some more. There's another case on this point, isn't there? Can you tell everyone about that, please?
Yeah, of course. So there's a case called Grand Lane Development and SkyMist Holdings, which is a 2019 case. Which is relevant to some of the issues you just mentioned. In this particular case, SkyMist claimed that Grand Lane had artificially inflated a number of payment applications in collusion with third parties.
Right. So why was the fraud insufficient here to resist enforcement then?
Well, on these particular facts, the court found again that there was no clear and unambiguous evidence of the alleged fraud.
Mm.
And the court reiterated that disagreements over payment applications don't automatically amount to fraud. The court also confirmed that the allegations of fraud were known at the time of the adjudication and therefore should have been raised there rather than subsequently at enforcement. The court also was at pains to emphasise the high evidential bar for establishing fraud and made clear this is difficult to satisfy.
Ah, interesting. So it's the same principles arising again throughout this case law. And it seems that, we've got loads of examples of where the court have rejected allegations of fraud. Has an allegation of fraud ever succeeded in resisting enforcement?
Yeah, so the key case here is called PBS Energo and Besta Generation UK. Relatively recently, 2020 case. As you said, in this particular case, the court decided not to enforce the adjudicated decision on the basis of successful fraud defence.
Right. So what were the key facts in that one then?
Well, in this one, the key points were Besta was the main contractor on the construction project and PBS was its subcontractor. The overall construction project was to deliver a biomass-fired energy plant, and PBS were engaged by Besta to provide bespoke mechanical parts, amongst other things. Unfortunately, the project was affected by delays and the parties ended up adjudicating on the final balance owed by Besta to PBS.
Yep.
As part of the adjudication, PBS claimed the cost of a series of bespoke mechanical parts, which it said Besta owed it in relation to, and the adjudicator actually agreed with PBS and awarded them the cost of these items. However, it was subsequently discovered after the adjudication that the mechanical parts hadn't been manufactured at all at the time of the adjudication, and had in fact been therefore fraudulently claimed by PBS as they hadn't suffered any loss in relation to these items. The court accepted this argument of fraud and refused to enforce the adjudicated decision, as the adjudication itself had been procured by fraud.
So that's interesting then. So the real kind of difference in that case then to the previous cases where the courts have rejected the allegations of fraud is that it wasn't known at the time of the adjudication that there had been this fraud. That was only discovered afterwards. So it wasn't possible for the fraud allegation to be raised during the adjudication. And that's why the court considered it during the enforcement proceedings. Is that right?
Yeah, that's absolutely right, Carly. And it can be contrasted with a few other cases as well. There's the first one to talk about is called Govner and Agan. In this particular case, the allegations of fraud related to invoices which were known to the parties at the time of the adjudication. Because the allegations of fraud were known but not raised during the adjudication in Govner, the court didn't accept the fraud defence at enforcement. So that's clearly a contrast to the PBS case just discussed.
Yeah.
Another example, which is similar, is called Assessment and Brookbecks. In this particular case, the allegations of fraud related to a site manager diary's entries and timesheets. But again, in this particular case, the facts of the alleged fraud were known to the parties at the time of the adjudication. So again, the courts said that the party should have argued the fraud points there and not simply waited till enforcement. The court also there emphasised the high evidential bar for fraud. The errors in the time sheets may have been simple human mistakes or genuine errors rather than deliberate fraud.
Yeah. I mean, why do you think the court makes this distinction between a fraud argument being raised during an adjudication or it being raised for the first time during the enforcement?
Well, I think the courts will usually decline to enforce an adjudication if a party can establish an arguable defence, such as fraud. However, the courts won't concern themselves to look into the substantive merits of the defence, whereas an adjudicator will be required to if the fraud was argued during the course of the adjudication itself. I mean, the general approach of the court is to enforce adjudicated decisions in the vast majority of cases, and really will only refuse to do so in quite a small, limited number of cases. So I suppose this approach is intended to dissuade parties from simply seeking to reopen factual disputes, such as allegations of fraud, at enforcement. Those issues should really be raised and argued in adjudications themselves.
Yeah, that's interesting. That really seems to be the key points from the court, doesn't it? That fraud allegations should be raised during the adjudication unless there's a good reason not to.
Absolutely.
Yeah, great, thank you. I mean, just to recap then, so on fraud, it seems that fraud allegations need to be raised as early as possible in the proceedings, and there'll be a really high evidential bar to demonstrate fraud, and that if for some reason you don't find out about the fraud until after the adjudication has taken place, it's really important to make that clear to the court at enforcement stage, because if not, the court won't accept that argument because they'll say that you should have raised it during the adjudication. Great. We're at the end of that topic now, so let's just check the Q&A. Oh, I can see we do have a question come in. So, Seamus, question for you. What can an adjudicator do if they suspect that a party is being less than truthful?
Yeah, it's a good question. And I suppose the most obvious thing an adjudicator can do is to call a meeting where he requires the two parties to attend. And at that meeting, the adjudicator would usually put questions to both parties and try to kind of iron out the difference and ultimately reach a view as to which party he believes is more credible. I don't think I've seen that in adjudication so far, but it remains a power open to adjudicators.
Yeah, really good point. I have actually seen that once where it was where there was a particular witness where his witness statement appeared to be that it might not have been necessarily entirely truthful. And so the adjudicator wanted to ask the witness some questions. But I think the real downside of that is the lack of time in the adjudication process, and the fact that if you're having a meeting where the adjudicator has to interrogate the evidence in that way, it's going to cost a lot more money for the parties in what's already a really expensive process. So I do think it's difficult for an adjudicator to identify a fraud independently.
Mm.
Excellent. Well, thank you, Seamus. Conscious of time, so let's move on to our second topic of the day, which is smash and grab adjudications. So, Amelia, what do we mean by a smash and grab adjudication?
So, under Section 111 of the Construction Act of 1996, an unpaid party has the right to be paid the notified sum by the final date for payment. If the paying party wants to pay less than the notified sum to the unpaid party, it must serve a pay less notice by the end of the prescribed period before the final date for payment. This pay less notice must set out the sum that the paying party considers to be due and the basis on which that sum is calculated. If the paying party fails to serve a valid payment notice or pay less notice, the unpaid party can claim payment of the notified sum by way of smash and grab adjudication. The valuation of the unpaid party's application at this point isn't relevant. So in summary, it's an adjudication claim based on lack of contractual notice.
Okay, great. So it's all about the missing notice rather than an actual valuation of the works themselves. So, I mean, it's a bit of a windfall, I suppose. And so if you're on the losing side of a smash and grab adjudication, what can you do about it? Is there an opportunity to request a true valuation of the works to try and get some of your money back?
There is, but the losing party has to pay first. And the key case to remember on this point is Grove Developments Limited and S&T, which is a case from 2018.
Okay, so really briefly then, what happened in that case?
So the judge held that it is possible for a paying party to adjudicate on the true value of an interim application in circumstances where no payment notice or pay less notice was given, and there's been a successful smash and grab adjudication. The judge gave a number of reasons for coming to his decision, including on the basis that the first adjudication was a smash and grab, and the issue to be referred in the second adjudication about the true value of the interim application makes them different disputes. And as a contractor can launch an adjudication in relation to the sum stated to be due at any time, it would be wrong in principle really to treat the employer any differently.
Okay, Great. So that's the key case that started all of this area off, I suppose. What about after Grove then? Have the courts offered any further guidance?
Yes, and for example, in a case called Davenport Builders Limited and Greer, it's a case from 2019, having issued a smash and grab adjudication against the Greers, Davenport was awarded the sums it had claimed, but the Greers didn't pay. The Greers instead issued an adjudication challenging the valuation of the accounts. And in this adjudication, the adjudicator did find that as a result of the revaluation, no sum was due to Davenport. In the subsequent enforcement proceedings, the judge concluded that before the Greers could rely on the decision made in the second adjudication, they were required to just discharge their immediate payment obligation from the first adjudication, the smash and grab. As a result, the Greers were ordered to pay over £100,000 plus interests and the costs of enforcement proceedings to Davenport. It is worth noting that though the judge suggested that there may be circumstances where payment made by an employer is not a prerequisite to relying on a subsequent true value adjudication, the most prudent course of action is still that the employer should pay now and argue later.
Okay, great. That's helpful. It seems like this is something that the courts have considered quite a few times. Can you give another example?
Yes, so in Bexheat Limited and Essex Services Group, a more recent case from 2022, this concerned an interim payment application dispute. Two adjudications are relevant to this case. The first was a true value and the second was a smash and grab. The adjudicator found in favour of Bexheat in the true value adjudication and issued his decision a day before the deadline for Essex to serve a pay less notice in respect of another interim payment application. Essex missed the deadline, so Bexheat issued the smash and grab adjudication. The adjudicator found in favour of Bexheat again, but Essex failed to pay the award. Bexheat therefore issued enforcement proceedings. Essex tried to argue that the true value of the interim payment application to which the first adjudication related could be set off against the interim payment application to which the second adjudication related. This argument was rejected for a number of reasons, one of them being that Essex had failed to raise this argument as defence in the second adjudication. And helpfully, in coming to their decision in this case, the judge reminded the parties that Section 111 of the Construction Act, which I referred to earlier, creates an immediate obligation to pay the notified sum, and that any right to adjudicate in order to obtain a true value of the notified sum is subjugated by the right to payment.
Okay, so the courts are really clear then that it's pay now, argue later, and that you can't avoid a smash and grab adjudication by then trying to get a true valuation. I don't think we've ever seen the courts accept a true valuation before the smash and grab has been paid.
That's right. The courts seem to reject any argument on that. A recent example, a case from 2022, is AM Construction and the Darrell Among Trust. Here, the employer started a true value adjudication without paying the notified sum. And the employer tried to argue that the doctrine of the employer complying with its obligation to pay a notified sum prior to issuing a true value adjudication only applied where an adjudicator's decision determined that there was a notified sum due. And the judge rejected this approach, confirming the fact that a notified sum being due was an absolute bar to any true value adjudication being started by the employer.
Yep. So again, really clear guidance from the court that if you're unlucky enough to be on the losing end of a smash and grab adjudication, you've got to pay it, and then you can ask for a true valuation afterwards, but you've actually got to pay out those monies, which might create cash flow difficulties or a risk that you wouldn't be able to recover those monies in the future. So I suppose how do we avoid being on the losing end of a smash and grab adjudication? I guess it all comes down to the notices. So we've seen that adjudicators have been increasingly reluctant to award smash and grab payments and they'll only accept such a claim in circumstances where the application for payment absolutely complies with all of the requirements of the contract. And similarly, if there exists a document which could be construed as being a valid payment notice or a pay less notice, we've seen adjudicators being willing to accept those, even though they might not necessarily be called a payment notice or called a pay less notice. So I think it's helpful to consider what actually amounts to a valid notice. So Amelia, what are the requirements of an application for payment, please?
So to be clear, the Construction Act doesn't contain an application for payment mechanism. However, many standard form contracts require the unpaid party to notify the paying party of the sums it considers will be due to it on the payment due date, and the basis on which that sum is calculated by way of a payment application. An example would be clause 4.7 of the JCT Design and Build Contract 2016 edition.
Yep.
Payment applications have to be clear and free from ambiguity regarding the sums the unpaid party considers are due to it. And payment applications should also strictly comply with the payment provisions of any relevant contract.
Okay, good advice. What about payment notices and pay less notices?
This was covered recently, actually, in a 2022 case, Advanced JB and Iniska. The judge enforced an adjudicator's decision that Advance did not issue a valid pay less notice against an interim payment application. The judge noted that in order to qualify as a valid notice, it has to comply with statutory and contractual requirements in substance and form. It also has to clearly set out the sum which is due or to be deducted and the calculation behind this sum. In making the decision, the judge helpfully noted that the Construction Act payment regime requires notices to be referable to individual payment cycles. There's no support in the Construction Act for the argument that a pay less notice could apply to 2 payment cycles. And a pay less notice must be in substance, form, and intent a pay less notice referable to a specific payment application. The judge also made clear that the construction of payment notices must be approached objectively. So in other words, how would a reasonable recipient interpret the payment notice, taking into account the relevant context?
I think that's a really important point, that, you know, from the court's view, it doesn't matter what the person who actually in fact received that notice thought that it was. So if that person genuinely didn't think that it was a payment notice or a pay less notice, that might not necessarily affect validity, because it's the objective view that counts.
Yes, and the courts are really clear on that. In Advance, the judge quoted from Coulson on construction adjudication, and I thought it was a really useful quote, so I'll just quickly read it out.
Yeah.
The courts will take a common sense, practical view of the contents of a pay less notice and will not adopt an unnecessarily restrictive interpretation of such a notice. It is thought that provided that the notice makes tolerably clear what is being held and why, the court will not strive to intervene or endeavour to find reasons that would render such a notice invalid or ineffective.
Yeah, then that's a good quote that just summarises that the courts appear to be more flexible with what would amount to be a payment notice or a pay less notice than the strict requirements of an application for payment. I think, you know, just to summarise it, it's clear that smash and grab still has draconian consequences, because if you're on the losing end, you'll have to pay before you can do anything about it. So it's really important to get your notices in on time and make sure that they comply with the requirements of the contract so that they're actually valid. Just looking at the Q&A. Oh, good. Here's a question for you, Amelia, please. What examples have you seen in practice of reasons why applications for payment have been found not to be valid by an adjudicator?
Yeah, the reasons that I've seen recently, often slight errors, non-compliances with the contract, such as the application being made for an incorrect period, or the application including insufficient calculations, or the fact that the application is an email that's been sent without actually being called an application for payment or including any proper calculations. And also as simply as the application being sent to the wrong person.
Yeah, I mean, we actually had a case on this recently, didn't we, where we were acting for a party on the receiving end of a smash and grab adjudication, and we actually managed to successfully argue that the application for payment itself wasn't valid, just on the basis that it covered a slightly different time period than what had been stated in the contract. So it's reinforcing that message, I think, that your application for payment does need to comply with all of the requirements of the contract, and it needs to be sent in accordance with the notice requirements of the contract so that you then can have that protection. Excellent. Thank you, Amelia. Let's move on to our next topic. So next up for you is natural justice, which a key principle in adjudication. Andy, hi. Could you please explain what do we mean when we say natural justice?
Hi, Carly. Well, what we're talking about is the concept of a fair hearing in front of an impartial tribunal. And I've described it as a concept, particularly in relation to adjudications, because there's no statutory right under the Construction Act to natural justice. And indeed, when the Construction Act came into force, that there was debate amongst lawyers as to whether this right applied to adjudications. The only case they had to go on was Maycobb versus Morrison from 1995, which said that natural justice did apply to an adjudicator's decision, but a breach did not prevent summary enforcement. So although it did apply, a breach of it had no consequence. It wasn't of much use to the parties, really. And we had to wait until 2005 in the case of Carillion versus Royal Devonport Dockyard for this to develop somewhat. It was established in that case that where there was a serious breach of natural justice, the court would not enforce the adjudication. It provided guidelines on how the court would decide what a serious breach was, but it also made the point in quite strong judicial language that in the overwhelming majority of cases, the loser must pay first and argue later. So this resulted in natural justice being viewed as a qualified right, and the qualification is that there must have been a serious breach of natural justice in order to prevent enforcement of an adjudication decision.
Thanks, Andy. It's an excellent, really good summary, because I think that really shows that natural justice has been something that the courts have had to get to grips with in the context of adjudication since the Construction Act came out, and it's something that's been developing over time. Like, as you said, we didn't get that real confirmation of it until 2005. What about recently? How have the courts dealt with natural justice in recent cases?
Well, we've seen encouraging signs of consistency in the case law. This can be highlighted by the case of Van Ord versus Dragados, which is just a classic case of the adjudicator going off on a frolic. And in this case, that was a dispute regarding a compensation event. The adjudicator, in awarding Van Ord both time and costs, used their own baseline program. They didn't use any of the programs put forward by either party, and as a consequence, neither party had an opportunity to make submissions on it. The court said that this was a breach of natural justice, a serious breach of natural justice, and declined to enforce the adjudicator's decision. And this is very much in line with previous such decisions in relation to an adjudicator going off on a frolic. So we can see case law precedent taking place and being established.
I love that phrase, the adjudicator going off on a frolic. It always makes me smile. What about the arguments that are being raised by parties to try and kind of avoid enforcement? What are the trends that we've seen in recent cases?
Over the last year or so, we've seen a number of cases, particularly on the parties not being given the opportunity to make submissions on the points which were relevant to the adjudicator's decisions. Over the last year, we have, however, seen some conflicting results in these cases, and we'll contrast two now. In the case of Liverpool City Council versus Vital, there was a dispute over the rate to be applied to a fencing contract. At one point in the contract, the rate was £2.20, and in another point, it was £2.20 per metre per day. The adjudicator decided that there was a typo or omission in the rates. They decided what the rate was and made an award based on that. The difficulty was that neither party had argued that there was a typo or an omission in the rates. One side had argued the lower rate applied, the other side had argued that the higher rate applied, as you would expect. Liverpool City Council, as a result, appealed, saying that neither party had made this point in adjudication and they'd not had a chance to make their submissions regarding this point. The Court of Appeal agreed with them and refused to enforce the adjudicator's decision. And you can contrast that case with the recent case of Bilton and Johnson versus Three Rivers. This was a case concerning liquidated damages. The work took place on the project under two contracts, each with a different rate of liquidated damages. Delay led to a dispute about which rate applied. The adjudicator in effect decided that the two contracts had become one. He made his decision based on that and awarded liquidated damages. But neither party had argued or made submissions about that element of the adjudicator's decision. Three Rivers resisted enforcement on the grounds that there was a breach of natural justice. However, the court in this instance found that the adjudicator had reached his decisions from the arguments that were made, although not directly. They concluded the adjudicator's decision flowed out of the arguments that had been made. And again, using quite strong language, they said that Three Rivers were not even close to showing a breach of natural justice. So we can see the contrast in two similar cases there.
Yeah, I mean, I think those two cases of the Liverpool one and the Bilton one are so interesting because when you look at the facts side by side, it seems like on face value, it's raising really similar issues, but actually they've led to two very different results and being, treated very differently by the courts. So, what does that mean? What conclusion can we draw from that?
Well, I think the first thing to say, although it might be a little trite, is that these cases are very fact specific and therefore caution should be exercised when applying previous cases to new matters. It also reinforces the point we made at the beginning that natural justice is a qualified right. It's not enough to just show a breach, you must show a serious breach. And consequently, as a result of this uncertainty around whether you'll be successful or not, it's always better to raise these issues at the adjudication if possible. If the adjudicator gives any indication that they're going off track from the arguments that have been made, raise it then. You're much more likely to be successful at adjudication than challenging that result in court.
Fab, thank you. I think, when you look at all of those cases, it's clear that natural justice is always going to be a difficult argument to run and that the courts will be looking at something really serious before they will accept it. Which I suppose is in line with that idea that, adjudication's rough and ready and it's a qualified right to natural justice. I've just been looking at the Q&A, Andy, and I can see that one has come in, a question. So thank you, whoever sent this one in, about natural justice. Let me read it out to you and then we can see what we think. Some of the cases you mention related to an adjudicator basing their decision upon something that neither party had argued or their own interpretation of something. What can an adjudicator do to avoid falling into this trap? What do you think, Andy?
Well, I suppose the main thing is that they could try and notify the parties before the decision is issued of the particular conclusion or interpretation they are making, and invite submissions on that point. This would then negate any future argument that there'd been a breach of natural justice. But that requires an insight by the adjudicator that they might be doing that, or they might be doing what the adjudicator did in Bilton, which is making reasonable decisions from arguments flowing from the arguments that were made. It would just prevent people trying to prevent enforcement, saying they hadn't had their fair say. And it also gives them the opportunity, where there's perhaps a gap in the information on the arguments that were made, for the adjudicator to ask questions of the parties in order to fill the gap. So I think that would probably be good advice to adjudicators to avoid seeing their decisions appealed on the basis of a breach of natural justice.
Yeah, I think that's a really good point. I was just thinking, like, I've definitely seen it in practice where an adjudicator has raised questions for the parties in order to just confirm a particular point or to ask further submissions on a particular point, almost kind of inviting parties to put forward their views in order to avoid this natural justice point. So, I mean, for example, I had one recently where the adjudicator said, please could the parties let me have their thoughts on the relevance of this particular case, and then quoted the actual case name on these facts on this dispute. And it was, an opportunity for us to go away and be like, oh, best look at that case and see what it means, and it, see how that applied. So I do think it's about engaging the parties to give them that opportunity to raise their submissions. Thank you, Andy. Again, conscious of time, so I'm going to move on to our last topic, which is insolvency. So obviously this is something that has been very prevalent of late in the construction industry, so definitely a hot topic. Sam, hi. Adjudication is an interim remedy, of course, and the courts will ordinarily enforce an adjudicator's decision, even if the adjudicator made an error of fact or law. And we've seen that, when we've talked about all of this smash and grab, natural justice, etc., which is essentially because the decision is capable of correction in later court proceedings or arbitration. But you get into difficulty where the party who is meant to be receiving payment following the adjudication is actually insolvent, because there's a risk that that company will be unable to reimburse the paying party in the event that the adjudicator's decision is then later corrected in litigation or arbitration. And there's also the fact that if you order payment back to one party, this distorts the process of accounting under the insolvency regime, where money has to be distributed for the benefit of all creditors, not just the particular parties in the adjudication. So the first kind of case of this that's really important was Buida and Dahl Johnson, which I always struggle to say that case. Apologies, everyone, if I've just butchered it. But that was where the Court of Appeal held that if you're seeking to enforce an adjudicator's decision and the party is in liquidation, then that could be a compelling reason for the court to refuse summary judgment on the basis that the money might not be able to be paid back. So, I mean, this creates the question of whether an adjudicator has jurisdiction to award in favour of an insolvent company. So, Sam, could you please explain how have the courts dealt with this issue of insolvent companies and adjudication?
Thanks, Callie. Yeah, I think the main case here really is Bresco and Lonsdale. So Lonsdale were the main contractor, appointed Bresco as their electrical subcontractor, and during the course of those works, Bresco went into liquidation. There was a multitude of disputes. Both parties claimed that the other was in repudiatory breach, both wanting damages from the other as well. Bresco brought an adjudication, and Lonsdale applied for an injunction to stop it going forwards. There was two grounds that Lonsdale raised. The first, as you mentioned, is jurisdiction. So, as you know, Carly, only one dispute can be brought in an adjudication, and the adjudicator only has jurisdiction to determine that one dispute. However, under the insolvency regulations, there's a procedure for automatic set-off of cross-claims, where ultimately you need to get to a single net balance due from one party to the other, whether that's owed to the company in liquidation or from the company in liquidation to the other. And so Lonsdale claimed that this goes beyond a single dispute and effectively is determining all the disputes between the parties in one go, and therefore an adjudicator wouldn't have jurisdiction to determine this. However, the courts didn't agree with this argument. Insolvency and the regulations don't prevent a single dispute from being raised in adjudication, and there's still a benefit in bringing issues to adjudication for an adjudicator to decide. For example, it could help parties to narrow down the overall dispute. If there's a variety of different disputes, so the adjudicator can determine one specific aspect of it, and overall that could help the parties reach a settlement, or at least it prevents more court time being used up determining things that could have already been resolved before actually getting to proceedings itself.
Yeah.
The second argument that Lonsdale raised was in relation to futility, and that's basically that adjudications are not enforceable, so therefore there's no point in bringing it at all. And again, the courts disagreed with this argument. They said that enforcement is a matter for enforcement proceedings, shouldn't be determined from the very beginning, that an adjudication simply shouldn't be brought because it's unenforceable later on. It is still possible and recognised by the courts that an adjudication could be enforced in these situations. I also mentioned as well that there is a benefit in bringing these adjudications over a single dispute anyway, so the courts are just again repeating the point that it does help for an adjudication to be brought if it means that the overall disputes can be narrowed down at the very least.
Right. Okay. So that case then makes clear that there is a right for an insolvent company to refer a dispute to adjudication and get an adjudicator's decision. But what about then when enforcing that decision? Will the courts enforce a decision in favour of a company in liquidation?
So despite the case I just mentioned saying that in principle the courts say that it is still enforceable, we saw in John Doyle and Erith Contractors. So John Doyle appointed by Erith Contractors to undertake landscape works, part of the 2012 Olympic Games. John Doyle went into liquidation, claimed about £4 million for their final account as outstanding payments. Adjudicator awarded about 1.2 million that Erith Contractors had to pay, and so John Doyle then applied for summary judgment. When the courts were assessing whether summary judgment of the adjudicator's decision was appropriate, they said there was three elements to consider. The first is whether the adjudication resolved all of the different elements of the overall financial dispute. So again, recognising the insolvency regulations applying. If there are any mutual dealings or other defences that don't form part of the adjudication, then can they be dealt with at the enforcement proceedings itself? And then the third point is that there was no real risk that enforcement deprives the paying party of security for its cross-claim. So in this situation, Erith Contractors said that had their own cross-claim basically against John Doyle for a substantial amount of money that this claim was owed. And it was held that if Erith Contractors had to pay out this 1.2 million, then there was a real risk that they wouldn't be able to recover those monies back. In this case, John Doyle had assigned to a third-party law firm their claim, and then a lot of the damages that would have been recovered would have automatically gone to that law firm. The law firm itself wasn't really providing any security for those damages if they were going to get a claim for those damages being recovered. And there was no undertaking provided by the liquidators either. So effectively, if Erith would have paid out, then their cross-claim for a substantial amount of monies would have probably been lost. The court said in this situation that there was a real risk, and also highlighted the fact that in order for there not to be a real risk of losing out, then security provided by either the liquidators or somebody else must be clear, evidenced, and unequivocal. And in that situation, then it could potentially be enforced, but that didn't apply here.
Yeah, so in principle then, a company in liquidation can enforce an adjudicator's decision, but then in practice, it seems that the bar for achieving that enforcement is really, really high, and we've not seen the courts actually accept that. So really difficult if you're a company in liquidation to achieve enforcement. Of course, there's differences in the types of insolvency. So what about other insolvency regimes? Do the courts treat those any differently?
So I guess we can compare this to CVAs, so company voluntary arrangements, where, for those who don't know, it's a procedure where a company reaches a binding compromise of its debts with its creditors. So a majority of creditors vote in favour of the proposals, and it binds all creditors. And the intention of CVAs is that the company can then potentially trade out of its debts. So you can differentiate this from liquidation, where effectively the company is going to be dissolved, and so there won't be any monies at the end of it. But even then, the courts have still found similarities between CVAs and the Insolvency Act. So in particular, CVAs can include similar wording where the company who's entering into this company voluntary arrangement will take into account all sums due between the parties and between the creditors to create effectively the same single net balance that the Insolvency Act requires. And where there's that specific word in the CVA, then the courts have generally taken quite a similar approach. So we've got two cases. There's West Shield Civil Engineering and White House, and the second case is Indigo Projects, London and Razin, where summary judgment was refused in both of those cases because of the CVA and the wording of the CVA. So in West Shield, the CVA had already been entered into by the time the adjudicator had made their decision. But in the Razin case, the same applied, where the summary judgment wasn't enforced, but the CVA wasn't entered into until after the adjudicator's decision had been made. So going into a bit more detail, I guess, with Razin, Razin engaged Indigo to build a house. There was a variety of different disputes, to be honest, but a lot of them related to defects and delays. During the course of this, Razin failed to issue a payment notice or a pay less notice, and so Indigo brought a smash and grab adjudication in relation to an interim payment. Adjudicator awarded in favour of Indigo, and as part of their decision said that Razin had to pay this interim payment. Razin naturally refused to do so, and a variety of different arguments in relation to defects, liquidated damages that were owed and whatnot, that would effectively be a cross claim. Indigo entered into a CVA and subsequently brought summary judgment against to try and enforce the adjudicator's decision, but it wasn't enforced by the courts. The courts ultimately considered that it was going to be quite harsh on Razin. The decision was a smash and grab, so it's recognised, and they said that the CVA supervisor would recognise that Indigo weren't actually entitled to those monies. There'd be the next payment procedure, and that would inevitably result in monies then being paid back to Razin. Whereas if those sums were paid by Razin at that time, then the monies would be distributed to all the creditors under the CVA and effectively prevents Razin from ever being able to recover those monies.
Right. So both of those cases show the court not awarding summary judgment when the company seeking payment is in a CVA. And when you look at that approach, it's very similar to how the courts deal with a company in liquidation. So it seems that, whatever form of insolvency regime you're in, it'll be really difficult to achieve enforcement.
Yeah, I think based on the cases that we've discussed so far, that is going to be the case. And a recent case as well, FTH Limited and Varus Developments. So here again, it's another CVA case, but it's really showing how similar CVAs are to the liquidation and insolvency cases that I first discussed. So here, again, another situation where there's several different adjudications relating to pay less notices, terminations and whatnot. Ultimately though, in the final adjudication, it was determined that FTH were entitled to about £750,000. FTH sought summary judgment for those monies. During this time, or shortly before the decision, FTH had entered into a CVA and Varys had raised their own cross claim of about £1.7 million. And the courts took a very similar approach as the John Doyle case that I first discussed, which is, sorry, I think it might be in the second, where if there's a real risk of Varys being deprived of their security for their counterclaim. And so in this case, the courts really took a deep dive into the situation and looked at the specific facts and determined that even though it was a CVA process, it was more akin to liquidation because there was going to be minimal recovery of sums and the chance of trading out of its debts wasn't particularly high. And so therefore, if Varys did pay out initially, then their counterclaim would effectively be, well, jeopardized really, and there would be a real risk that they wouldn't be able to recover those monies again. So in that case, summary judgment was refused again. I would say these CVA cases are very fact specific though. So
Okay.
mentioned at the beginning with the CVA wording, they do include very similar wording about this net sum single balance due as the Insolvency Act. It's not always going to be the case that CVA would include it, but in these cases particularly, the courts saw such wording as being very similar to the Insolvency Act wording.
Right. So in principle, it might be possible to get an enforcement. It depends upon the actual wording of the specific CVA.
Yeah, well, that's one of the facts, and then also just the very fact-specific situation about even if it is a CVA, what are the chances of like monies actually being recovered from a cross-claim as well? So, is it going to effectively put a dent in any form of being able to recover your monies back? Razin, again, where the courts overall just said it was a harsh decision to enforce it because it was recognising that they probably wouldn't be able to get those monies back in a situation where they were only paying because of a smash and grab. As Amelia said, it's more of a procedural situation of these adjudications rather than actually being entitled to those monies.
Yeah, good point. Great, thank you. Well, to summarize then, so after Bresco, it's clear that, in principle, a company in insolvency can refer a dispute to adjudication. They can get an adjudicator's decision, but there may be issues in achieving enforcement. So just flipping that around, if you're a party that's in dispute with a company that goes into insolvency, you might still have a situation where you're having to incur the cost of defending adjudication proceedings, even though that company is insolvent. But when it comes to actually enforcing that adjudicator's decision, this line of case law really demonstrates that there's lots of arguments you can raise to try and resist enforcement. So I think because it's so fact specific, it'll be really interesting to see what cases come out in the near future that relate to insolvency. So thank you, Sam. We've just got a couple of minutes left, so I'm going to pull a question out of the Q&A for you because I thought I've seen this one come in. I thought it was a good one. Is there any point to referring a dispute to adjudication for an insolvent company? What do you think?
For an insolvent company?
Yeah. So I think like if you are an insolvent company, is it worth like bothering to even get an adjudicator's decision? I think that's the question.
I guess it depends on what you're wanting out of the situation. From the cases that I've discussed today, actually having that adjudicator's decision enforced is going to be difficult. So if you bring in an adjudication as an insolvent company in order to be able to actually get the monies at the end, then that there will be an uphill battle to be able to get that, and it will be a struggle because we've seen from case law that the courts will put some quite stringent tests in relation to if there's going to be a real risk of counterclaims being lost, for example. So if your end game is to try and get payment out of it, then question whether it is worth going to the hassle of adjudications. But the courts have also recognised that there is valid times where an adjudication can be brought over a single dispute. So it may be the case that there's one specific area where the parties are massively in disagreement over a certain value, and the adjudicator can determine that aspect without determining the whole situation, and that's just narrowing down the disputes, meaning that the parties could then maybe enter into settlement discussions a bit easier, or otherwise it's just something that the courts then don't need to assess when you get to court proceedings. So I think it could be a useful tool for parties to try and narrow the disputes, but if the insolvent company is trying to look for actually getting payment out of it, then I think it might be something to really consider the chances of success at enforcement stage afterwards, which, as we've seen, has been quite difficult.
Yeah, I agree. Yeah. Well, there might be some point to adjudication then, but it really depends upon what dispute is actually being referred. Excellent. Well, let's wrap it up there then. Thank you very much, everyone, for joining us. As I've said, we'll be sending out a handout afterwards to each of you, which contains details of the cases that we've discussed today. If you have any comments, feedback, suggestions following this webinar, please do get in touch with us. And if you liked what you heard today, please do sign up for our Adjudication Matters Bulletin, which we send out every month, updating on all things that are happening in adjudication enforcement. So thank you very much, everyone, and enjoy the rest of your day. Thank you.